Okay. Oh, I'm sorry, I didn't know we went live. We are taking up an act relating to restorative justice approaches. H 645 is Ben Novogowski from Legislative Council is with us, and we're walking through draft 1.2, excuse me. So Ben, you were just on page 2 at the top, community referral means.
Yep. So for the record, Ben Novogowski from Office of Legislative Counsel. The changes that you see on page 2 adds a definition of community referral, which means a referral of an individual to a community-based restorative justice provider that does not involve criminal offenses or delinquency for which probable cause exists. And then you'll see that that definition is added on, or is mentioned on lines 9 through 10, so that pre-charge diversion shall not be construed to include a community referral. So it separates the two. And then you'll see on lines 6 and 7 the change from "and" so that the officer or the prosecutor can determine that probable cause exists. So we basically changed back to the initial version on that language.
But I heard testimony from the state's attorneys that the requirement for probable cause could limit the number of people who would get diverted pre-charge.
I suppose that's a possibility, where there's that, I think sort of what the testimony was, there's a certain momentum at that point. And so if they're going to go through with kind of a probable cause analysis, they might just charge the individual. But so if it doesn't go through pre-charge, presumably there's still an opportunity for post-charge diversion in that situation.
The other piece that we added in here was around the community referral. So if probable cause doesn't exist, or probable cause is too hard to prove, they can still go through the community referral. So there's sort of multiple avenues to make sure we capture everyone in the right system.
Okay, if you want to continue.
Sure. The next change is on page 3, which is just striking the reference to reasonable suspicion. And now it just emphasizes that pre-charge is for where a child or youth has committed any criminal offense. So make sure that there's no restriction there as to what types of offenses are eligible for it. And the next change is on page 11, which this was I believe at the request of the CJCs. So in the confidentiality, their portion, and this is mirrored in the adult section as well, that there are some limited exceptions where confidentiality could be broken. Previously, it's essentially where someone is a threat to themselves or others, as a general point of view. But there was a request that coordination between providers would be necessary if there's an individual that might have multiple referrals to different providers, that basically they could talk to each other about that individual to coordinate what to do about the person. So if the Williston CJC and the Burlington CJC have referrals for the same person, they could talk to each other and essentially say that, Burlington, you're going to handle the cases for everybody, for us as well. I would defer to Rachel Jolly to maybe elaborate a little bit more on that. But that's ultimately the goal for this limited disclosure or use of information for specific persons to facilitate. I'm sorry, Senator Sears, did you say something?
That makes sense. I said it makes sense. That they can talk about a client who's they both serve.
Right. And then that's reflected in the adult portion, but the only other change is all the way at the bottom, not to make everybody dizzy. is just when community referrals, when the study about community referrals in section 9 is mentioned, it just now changes the definition to what was outlined at the top of the bill. So just a cross-reference to community referral. And that's really the difference between the last version and this one.
Okay, on page 30, you've repeated the language, right?
Yes, and that's just because it's in the adult portion.
Yeah. All right, are there any other questions for Ben? Any, is Rachel there?
I am here.
Okay, if you wanna, I think one of your concerns is answered in the.
It has been, yep, the first one. Yeah, so for the record, Rachel Jolly, I'm the director at the Burlington Community Justice Center and on the legislative committee for the CJCs. So you're right, the written remarks that I've already submitted, and the point number 1 has already been taken care of with the substitution of or from and on page 2. So I have just 2 points. One is I wanted to bring up on page 4, because one of the goals of the bill has been to ensure stable funding for restorative justice programs. Funding for RJ programs we'd like to be included in that following section. So we're asking on page 4 to add restorative justice programs when it lists out the different stakeholders that need to have, the juvenile pre-charge diversion program established pursuant to this section shall operate only to the extent funds are appropriated to the Office of the Attorney General, et cetera. And so we're asking that and restorative justice programs to carry out the program. That could be assumed by some in terms of the interpretation, but we thought it may be better to make it explicit. And then on section 7, page 58 through 59, some of the CJCs just wanted to draw attention to the deadline, given that the deadline for the report for the plan to streamline the administration and provision of juvenile and adult pre-charge and post-charge diversion programs was changed from July 1st, 2027 to April 1st, 2025. Some feel like this is going to definitely require conversations with municipalities or select boards, and given that it's not determined yet if there will be funding for H645 to go into effect until on July 1st, 2025. If that's unknown and having the plan due by April 1st, 2025, it seems like maybe that might be too early a date. So just wanted to pose that for consideration by the committee.
Okay, thank you.
Thank you.
Question? Senator Bowles.
Yeah, so this report is due from the Attorney General, and my understanding was the Attorney General felt they could get this to us by April 1st, 2025. So I guess I'm just confused.
Yeah, the Attorney General would need to work with the providers that would be impacted, and they in turn would need to work with their governing bodies. For instance, if they're nonprofits, with their board of directors, or if they're under the municipalities with their select boards, for instance. And so to have a detailed plan before even knowing if funding is available is a lot of work prior to knowing the certainty of that. Depending on how detailed that plan needs to be, maybe it would work if it doesn't need to be very detailed. For instance, if the plan could say providers would work with their board of directors or select board to come up with a more detailed plan, if that kind of general plan was due by April 1st, maybe it's doable. Does that make sense?
Yeah, it does. Just given that it's tasked to the Attorney General's office, I want to believe that they would not say they could do something that they don't think they could do.
I know Willa has been consistent all along in all of her testimony that obviously the Attorney General's office couldn't do this without funding. So we want to, we would assume that funding is going along with it. And we're assuming that like some of the CJCs, when they hear the word plan, might imagine a very detailed plan that does involve a lot of other kind of behind the scenes conversations. So if we can interpret the term plan loosely, and then I think that would be fine for all.
Willa, do you have any comment on this?
Thank you, Senator Sears. Willa Farrell, Attorney General's Office. I do believe that the date of April 1st is reasonable. It would certainly be a lot of work, but I do think that's viable and feasible. I spoke earlier this week already with 2 of the Community Justice Center directors in Chittenden County. That there has been existing conversations in that county, for example, about how to streamline services. So I don't think we're starting from scratch. And as Rachel Jolly indicated, to me, there's scope here for us to present a plan that may not reach us to full streamlined system, but would set a path forward. So I believe firmly in having a deadline to encourage us all to move as expeditiously as possible towards the goal.
One of the benefits to me of April 1st is it's before the legislature would adjourn, and if there are issues that come up, the Senate probably hasn't even dealt with the budget yet or finalized it. This committee could still, depending on who's here, could still work on issues and put them into a bill. So I think that April 1st gives more time for any changes that need to be made in 2025 rather than waiting until 2026.
That's a good point, Senator Sears, and I also think by that date, well, we would at least know what's in the governor's proposed budget and have an indication of what the House version of the budget is. So I do think there would be information about funding for FY26 available as of January for us to be including that in our planning.
Well, and then the other issue that you raised is around the funding and being part of that. I don't have a particular problem with adding community justice centers. I just warn you, it doesn't do you any good. If you looked at the governor's budget and you were the state's attorneys, the judiciary, or the defender general, you would say he didn't pay any attention to that. And proven in this year's budget where the Senate just added 8.5 million, including money for the community justice centers, I might add, to try to shore up what was a total of $22 million of need versus what we could afford was 8.5 in addition to what the governor proposed. So the governor basically underfunded those agencies that you were just speaking of by $22 million. Well,
Your point is noted.
pardon me?
I appreciate that point.
Yeah, so we can put it in there.
Putting it in there, if that makes sense.
If I may speak to that point, Senator, when I read this, the mechanism for funding these services is to flow through the Attorney General's office, not to appropriate directly to community-based providers. So as I read this, if funds are appropriated to the Attorney General's office by this proposed bill, we would then have to fund, our office is not going to do the direct services. So I appreciate the concern, but as I read this, appropriate to the AG's office means that court diversion line item would have funding.
And for other agencies, it's the Department of Children and Families and Department of Corrections that they rely on. So your point's well taken. I don't think it makes any difference whether we do or we don't. There's a commitment on behalf, at least I will say, from the Senate Judiciary Committee and the Senate Appropriations Committee. That's currently construed, who knows what it'll be like next year. But there is a commitment to community justice centers, I think. So, anyhow, thank you very much, Rachel.
Thank you.
Is everybody okay with the changes? And, oh, I'm sorry.
I have one question. It's my fault because I showed up a minute late, but just going back to page 2 regarding the community referrals and probable cause conversation that we've had a lot of, I just want to confirm or clarify what this section does and if it gets to the concerns that we heard about for non-criminal incidents, you know, like maybe neighborly disputes that are almost rising to that criminal level, you know, being sent to a sort of mediation, but there's no potential for charges, but it's sort of.
It's a great point. I actually have an example. I had a case which I tried to deal with where the neighbor cut the limbs off of the other neighbor's trees that were on his property, and it was a valuable tree and a rare tree or something like that, only in Manchester, Vermont. And they were in a huge dispute. And no, you're right, no crime had been computed, but God, there was gonna be one pretty soon, and they couldn't settle it, so.
So is that sort of thing
Is
able
that sort
to?
of thing in there, Ben, or Philip?
I think that would be captured by community referrals, the way I read this, you know.
Yeah.
So
Yes.
they could refer the two neighbors
Okay,
in the dispute. Yeah,
I know that was a
it was one
concern.
of the strangest cases I've ever been confronted with by constituents who.
Well, I don't know if you remember the Rand Paul incident. He had a
Yes, yeah.
dispute with his neighbor over brush and whose yard it was on. And Rand Paul was out there making more brush that was gonna go on the guys, and the neighbor just attacked him.
Yeah.
And put him in the hospital.
Well, I think in that instance, a crime had been committed.
Yes. But we're talking about getting.
Yes,
Well, these
intervening
neighbors
before.
had-
Yes.
These neighbors hadn't actually committed a crime yet.
There had
Right.
been no assault
There
yet.
would be.
Right.
It was
Well, it
getting.
was an assault on the tree. Let's put it that way.
I do actually think somewhere in statute, we do have some protections for trees. I vaguely remember it in the technical corrections bill
It is
last year.
property, like,
Something along the lines of not being allowed to molest trees.
is that actually the way we?
I believe it is.
All right. I think we're getting a far of.
Yes.
That
Senator.
satisfies me that those, thanks for bringing that up, Senator Shum.
Yeah, that is why we put that language in, to make sure that both avenues are
So-
represented.
Are there any other changes, comments regarding the bill? I would entertain a motion to report favorably as amended.
I would move that we report draft, it's gonna be 2.1
Yep,
favorably.
1.2.
Right, but 2.1, I think, is the one that's clean, that Ben's gonna give us.
Right.
Um,
So just to
so
clarify
2.1
though, I do have a question. So are we making the changes as far as the funding to providers and the report change, or we're keeping it?
No,
as
I
is?
think Will have brought up an important point.
Okay,
So I would move that we find draft 2.1 favorably, as amended, report it favorably. I'm really bad at this, making motions.
I think you're doing great.
Thank you.
Well, I think we got it.
The only thing, I hope that we can, talk about this for next year's budget, because I know this year's budget has largely sailed. I know that the Department of State's attorneys and sheriffs would like a central office position to manage restorative justice. And so hopefully we can consider that in next year's budget
Well, and they could do that in this year's budget if they so choose.
with one of the positions that they have been given.
Positions that just been, they have, I believe, enough for 12 new positions within the department. So they could certainly take one of those 12 and make it into, and that doesn't include the 9, we covered their 9 vacancies in the budget.
There are pretend vacancies.
So they could have 10 vacancies, but they don't have 9.
Exactly, that's why I
That
said
was
they're
the problem.
pretend vacancies.
They're pretend vacancies. So, is there any further discussion?
I just want to say thank you to the committee. This is important to me. Restorative
So-
justice is really important to me, and I know
No,
this to you as well, so
yeah.
I just want to say thank you.
Important. So Ben, hearing no discussion, do you want to call the roll?
Senator Booth,
Yes.
Senator Norris,
Yes.
Senator Wolski,
Yes.
Senator Rishi,
Yes.
Senator Sears,
Yes.
Observer,
And I would like to ask Senator Bowski to report the bill, since she did extensive work outside the committee to put us where we're at.
It would be an honor.
That's a long bill, you can certainly take your time
I might read it.
in the report, read the whole report, do a Terry Williams.
Yep, I might read it to everyone. Buckle up.
Once again, we're running ahead of schedule.
Okay, so if Eric's not available until 10, or is he?
I am checking right now.
I need to be here for this next bill.
I think I can get him here.
You don't wanna be?
All right.
So don't need me.
How come?
I was a no on it originally. And the house just screwed it all again, so.
But we need the input. Even if you're not with the majority.
Imagine a 5-0 vote out here.
I apologize.
We do that sometimes.
We get some 5-0s.
We've had a lot this session.
Huh?
There's been a lot of 5-0s this session, I feel like.
Yeah. While you're sitting around, total up to 5 zeros.
All right, let me get.
I mean, I'd really like, what would be helpful is a list of bills out of committee
Yes, I can do
for the committee, so we can follow what's going on with our bills and the other body.
that. Let me get you.
The House Judiciary just voted out S-196. So,
What was that?
House Judiciary just voted out S-196 this morning, so.
Ah, yeah, I heard
Which bill?
the one that confused everyone.
Oh,
The
your
weight
bill?
of the evidence
Oh.
hearing.
Your bill.
A little bit of a throwback for everyone, that's 209.
I remember.
Everybody have a nice day. Thanks for accommodating me.
Feel better,
Well,
Ben?
thank you, Ben. Hope you get better.
Senator, I don't have your folder, I think you. That's
Did you
209.
lose your folder?
Bad committee
Did you put
member.
it back? It's in
I
there.
don't know if I may have taken it, and I know where it is,
No worries, it's just,
in my briefcase.
we're just
that I
looking
left
at
in my-
the draft from the House, so I can just give you
Yeah,
that.
thank you.
Orange.
Give you all these folders then
We'll
before.
just pass that down.
Thank you.
Can I give you these?
That's what we're looking at.
So the changes are in yellow.
Oh. Well, let's see this.
No email from Eric, but he's scheduled for 2 minutes, so I assume he'll be down
So
shortly.
how do you unknowingly transfer a firearm?
I mean, I guess if you were unaware that it didn't have a serial number, that,
I'm just curious, how you'd be unaware you just transferred a firearm? So not knowingly transfer or often transfer.
I mean, we had it in our definition too, they just pulled it out as a, but yes, it is maybe you tripped and threw it at the person?
Maybe. I don't like the idea of it being a civil penalty, Jim. Jesus. Civil penalty of 50, 250 and 500?
That's just the cost of doing business.
Yeah, I mean, God. The gun's probably a lot more, worth a lot more than that. Well, or while committing reckless endangerment, okay. The other one, I guess we better have Eric explain it. The difference is what they created specifically.
Morning. How are ya?
Well, Eric, this is bringing a lot of changes.
That'll happen.
I will lay in that at your feet.
Yes, I recommended all of them. Changes are in your, well, I didn't want to start. I'm not talking about it yet.
Oh, we are live.
Oh, there.
Yes.
Good morning, everyone. This is Eric Fitzpatrick with the Office of Legislative Counsel. Here to walk the committee through the House proposed changes to S-209, which is an act relating to prohibiting unserialized firearms and unserialized firearms frames and receivers. The committee may recall that when the bill passed the Senate, it prohibited basically three types of conduct with respect to these unserialized firearms and firearms frames and receivers, and that was possession, transfer, manufacture. Remember, each of those things were prohibited, and there was sort of a tiered system of penalties for those based on first offense, second offense, that sort of thing. So generally, the first two offenses were misdemeanors, third offense and subsequent were felonies. So the first major change in what the House proposed has to do not with the offenses themselves, but with the penalty structure. And what they did was they separated out possession from transfer and manufacture. So with respect to, so they kept the same prohibited conduct, but with respect to possession, they said first couple offenses are going to be civil offenses. So civil penalties. So if you look, for example, at page 3 and 4, kind of together, but you see, here's an example. This has to do with the unfinished frames or receivers. This is on page 3. So you see, as it left the Senate, the prohibition on possession, transfer were both in the same subdivision, and they both had criminal penalties. What they proposed to do is to say, well, transfer is going to be separate from possession. And just to turn ahead so you can see this, if you look over at page 5, you see how it connects. So a possession offense, which is what you're looking at there, starting on line 13, page 5, those will have the civil penalties for possession. So first offense, civil penalty $50, second offense $250, third or subsequent $500. Then if you turn the page, you'll see that the Senate penalties still apply to transfer.
Okay. So if I possess the firearm and I may use it, right? There's nothing to prevent me from using it. It's a civil penalty. But if I transfer it, that's when it's a criminal penalty?
Exactly.
So how does that help my constituents? Not those constituents. How does it help my law enforcement in dealing with the problem of ghost guns being possessed by gang members in Bennington and Rutland and Pownell and other areas of my community? Deal with the problem of those individuals possessing ghost guns and using them just as if they are a regular firearm, and they've never been through a background check, they've never had to go through anything. I think this really weakens the bill tremendously. Senator Bruce.
Oh, I'm sorry.
Senator Bowles.
Well, so my question is if we have any precedent for civil penalties for illegal gun possession? Like, is there any other place where we say it's a civil penalty for illegally possess this weapon?
I'm not sure off the top of my head. I think the hospital statute you passed a couple of years ago, it might have been fine only.
And then it got reduced to $250.
Yes.
In the final. So this is obviously a tack that House Judiciary takes to not have criminal penalties, to have civil penalties, and to bring the fines down. But I agree with Senator Sears completely. If you get caught once and you pay $50, and then you get caught a second time and you pay $250, that's $300 total for two, in my mind, major offenses, which is you have unserialized weapons. Why? Because you're trying to avoid the regime of background checks. So this is tough for me to go along with. It just takes teeth out of the bill. I mean, obviously transfer, they're treating kind of like dealing drugs as opposed to possessing drugs.
I mean, the transfer is another problem, but but the problem is the possession of these firearms that are unregulated.
But is it still criminal for the transfer to be?
Yes.
Yeah.
The
Just wanted to
transfer
make
is criminal
And manufacture.
and manufacturers are good. But the simple possession of a ghost gun became a civil offense. And that, I think, undermines the public safety aspect of it.
And is there still the exclusion, though, that if you're in temporary possession with the intent of getting it serialized in the near future, that
That was in our bill.
Yes,
that
although
still in
the
there?
only, the slight change to that, you'll see it, for example, top of page 4. So it includes, all it does is strike, the change there is to strike the word temporary. They had there was a long debate of what does it mean for it to really be temporary? And they landed on the idea that, well, isn't the point that you're possessing it in order to have its serial number put on it? That's the exclusion. So the word temporary didn't really seem technically necessary in that sense. So they preserved the idea that they avoid the argument of whether someone could say, oh, well, this was temporary or it wasn't.
I mean, if we're getting rid of temporary, then I would be fine with having it go back to the criminal
Well,
offenses.
we're keeping temporary. The exemption for the temporary, if you're intent.
Right.
Looking at line 10 on page 5, that's, it's struck temporary, put possession in.
Right.
But might confuse.
So that's, should we move on and see what a couple of the other changes are? You want to discuss this one a bit more? So that's one concept. The second one you just were alluding to, which is the slight change in wording on the exception for possessing or transferring the firearm with the purpose of having it serialized later on. So that's still an exemption. I went through the distinctions between civil and criminal. So over on page 6 is the next change, and this is subdivision 3. Now, you remember this, the committee created a separate crime for using an unserialized firearm while committing a violent crime. Remember that? So that's separate from this possession and transfer idea. If you use it while you commit a violent crime, that's a 5-year felony in and of itself. So the couple of changes they made to that was they broadened it. You'll see in line 9 somewhat, so that it's not used, it's carries. So remember, we went through that in this committee.
Yep.
The distinction, so carries sweeps in some more conduct than uses does. And their, I think, perspective on that was, as you were saying, since they're sort of softening it a bit with respect to the civil penalty, they would broaden the crime by using carries.
So if we do away with the civil penalty, we don't need to do this.
Yeah, completely up to you.
Well, I understand you, I'm sorry, that wasn't a question, it was a comment.
Right, yeah.
Committee, if we do away with the civil penalty, we don't have to do this.
Well, I don't think we have to do this either way.
Well, but I'm sorry for asking you.
No, that's okay.
Who are supposed to be who's neutral,
Right.
except when it comes to the Yankees.
I know, I have a hard time trying to be unbiased.
Anyway, okay, so I think we understand this. I also I like uses better than carries, but
They also added one offense there, you see.
yeah,
that they're
reckless
not-
endangerment.
Yeah,
What constitutes reckless endangerment? I'm not really
well,
sure what that means.
interestingly, which I remember from my very first year working here was with Senator Luzzi proposed and the legislature added some language to the reckless endangerment statute that specifically says that pointing a firearm at somebody, whether or not it's loaded, constitutes reckless endangerment. That's expressed in the statute. So that's,
brandishing is.
yeah,
Is that-
well, pointing at somebody. I don't know, there may be a distinction there between
Yeah.
brandishing, but pointing at,
So you put them in reasonable expectation of that.
Yes.
Might be.
Is that
Yeah.
the only thing that constitutes reckless endangerment, or could that be
There's other things.
yeah, there's other things.
what?
The most common example that I experienced was basically somebody shooting at another house or close to another house. So if, you have a somewhat rural area and maybe a house right here and then a house right here, and somebody's shooting across. I mean, it depends on the facts and, what's being shot at and how close it is to the house. But That was the most common thing that I saw.
Yeah, okay. I just, with crimes like reckless endangerment, and there was another one that I had an issue with last year, I can't remember which one it was now, that are just widely open to interpretation, I get worried that like all kinds of things, especially changing from uses to carries, because you're focusing entirely on crimes that, reckless endangerment that uses guns, but I imagine it applies to things that don't use guns.
Yes, I just pulled up the languages. A person who recklessly engages in conduct which places or may place another person in danger of death or serious bodily injury. That's it, shall be blah, blah, blah. Recklessness and danger shall be presumed where a person knowingly points a firearm at or in the direction of another, whether or not the actor believed the firearm to be loaded and whether or not the firearm actually was loaded.
I would go back to our language in this section and not use theirs. Back to our uses.
Mm-hmm.
Yeah, because my concern
And
is.
not add the crime of reckless endangerment, because it's already there if you're using it.
Yeah.
You brandished it, or no question that you're trying to intimidate with the ghost gun.
I see.
So I don't care whether it's, I don't think they need to prove reckless endangerment. You've already, by our laws, by what I understand of the differences between uses and carries, you're using it in the commission of the felony.
I agree, and so I'm like thinking, if we stay with the language here and it's carries and includes reckless endangerment, I could have it in my backpack and drive my bicycle into a crowd of people, and now I've committed a 5-year felony.
So the next page is on.
No, sorry, I think carries isn't just possesses, you may remember.
Carries is in the trunk.
No, I think that's, because,
Yeah,
but if it's in my backpack,
Right,
I would think that that would meet the carry.
that covers the carrying piece. The Supreme Court said that for it to be carrying, it has to also be potentially further the commission of the underlying crime. Not that you used it in the commission of the crime, but it potentially could further the underlying crime. So I didn't catch what the underlying crime was in that one, but there would have to be some
I
connection.
recklessly drove my bicycle into a crowd of people that I was mad at.
Right.
If I did it
Might be a
with it in my
stretch.
hand, maybe, but my point is
It is broader for sure.
it's much broader, and I think it starts to suck stuff in that wasn't the intent.
Right.
I agree about going back to our language there.
So
Yes, exactly.
we would not be doing this.
Right.
Okay, now we go to a waiting period.
Yes. So you may,
Okay, get in here.
this got added in the House.
Oh.
And you may recall, this has to do with the waiting period on firearms transfers that you passed last year. So remember, there's a 72-hour waiting period generally on firearm transfers.
Except gun shows.
That's exactly what this relates to. Yes, there's an exception for gun shows that passed last year with a 1-year sunset. So that exception for gun shows is set to sunset this coming July 1st, 2024. What the House proposed to do, you'll see line 9, page 16, is to extend that sunset by 1 year. So the exception for gun shows would continue for 1 more year.
So I know that this had to do with agreements that were made in the other body. It makes zero sense to me. The 1-year sunset, no sense, so that people could get the idea that they could no longer show up at the Sheraton and go into the lobby and walk out with a gun. But extending it seems to me to be saying that we want to move in the direction of carving out gun shows. And to me, gun shows are the worst loophole that we've had the hardest time closing. So extending this for another year, just, I don't understand it at all. We were talking about the 3-day waiting period, reducing suicide and homicide. And so at a federal dealer, you have to wait 3 days. But for somebody that nobody knows who goes into town on Friday and opens up a suitcase full of guns, we're saying there wouldn't be a waiting period. I don't know how that makes sense in anybody's mind, except thinking about the convenience of people who would like to walk out with a weapon.
I agree. It is inconvenient to wait 3 days.
Yeah.
I recently waited 3 days. It was very inconvenient. but I did it because that's the law, and because the firearm dealer wouldn't have allowed me to violate the law even if I wanted to. It is very inconvenient, and particularly if you're buying the firearm at a distance from your home, you have to return to the firearm dealer and so forth, but. And I never really agreed, as you know, with 72 hours. I thought it should have been 48 at the most. But I live to accept those things. But it is inconvenient, but it's inconvenient for a reason. And the legislature and the governor decided that it was worth the wait, and that the United States Supreme Court would be making a decision in the near future on whether or not waiting periods are constitutional. And based on the Colorado law, which is similar, not exactly the same as ours. So I think waiting for that Supreme Court decision makes sense at this point, and not giving a further exemption to them, even though, you know, it does make it easier, I'll admit.
I mean, if we're all weighing in, I agree that pushing it out again doesn't really make any sense.
Yeah, unless you plan to do this every year.
Well, we've seen that.
I mean, unless you plan, like, raise the age.
Yes.
Put it out another year, put it out another year.
Right.
Unless you intend to keep doing this.
No, I just think it sends exactly the wrong message, as well as allows people that we don't know in the community to evade the 3-day waiting.
All right, so. Anything else change?
Well, yes,
Oh,
so
yes.
there's one more subsection F is new. So this has to do with, you remember this is connected to the ghost guns. You remember, that we didn't really talk about this so much again just now, but remember the ghost guns piece also contained that process for FFLs to put serial numbers on firearms and frames and receivers, right? So people can, it has that delayed effective date, which I think might even be bumped out a little bit in this bill. Yeah, I think it was December 31st when it left, and they bumped it out a couple of months to February 28th, 2025. So at any rate, as that extended effective date, remember the idea is allows people to go into the dealer and have them put a serial number on your firearm. The question came up is, well, does the 72-hour waiting period, because remember, under federal law, for example, you can bring in, you have to do a background check. Say you bring in your own part or your own homemade firearm. You make it at home, you bring it into the dealer so they can put a serial number on it. They can do it and give it right back to you. But under this law that you're passing, they have to do a background check, right? Question was, does the 72-hour waiting period apply?
Yes.
Well, they determined that they would prefer that it did not. So that's the subsection F does. If you bring your own firearm, if they just are returning it to you, you bring it in, hey, can you put a firearm on this? And they return it to you without transfer, it doesn't get transferred to some other person.
This is a ghost gun. The whole purpose of the bill is that the person who created it in their living room, and there's no background check. So
No, right, the background check, I think they felt was sufficient.
Well, the background check takes place, but then you walk out with a gun, and then 3 days later, the federal firearms dealer finds out that you shouldn't have had that gun.
Well, the delay would still apply. If you got caught up in the default proceed, in other words, only if you pass the background check would you be given the firearm back. If something comes up in your flag, either with a no or a, hey, we need to look at this a little bit more, then, which I think under, what did we pass, 7 days? I think there's a 7-day default proceed in Vermont. The 3 days is under federal law. So
maybe I don't understand this enough. Senator Biles.
Oh, that was my question, is if that week that we passed a few years ago would apply.
It would.
Okay, so if someone's taking in an already functional firearm to be serialized and passes the background check, I don't really feel strongly that they should all have to wait the 72 hours, because they already had it. If they were going to go use it to harm themselves or someone else, they probably aren't going to get it serialized on the way. So I feel like I don't have, given that 1 week default proceed does apply, I don't feel strongly that they have to wait the 72 hours.
I wanted to echo that. I had the question about the default proceed, but also the same concept. I mean, if somebody's in possession of an operational firearm and they're going to get it serialized, they're getting their background check, the default proceed rule still applies. If they don't pass the background check, they don't get their gun.
Correct.
If they do pass it, then they get their firearm back that they've already had in their possession for however many days. And I don't think, somebody who's on the way to, commit a homicide is going to say, oh, I want to make sure I get this serialized first. So.
No, I can agree. Thanks, Jerry.
12:45.
Okay, I can agree with that. I think that makes sense in a way that the other did not, the gun show piece, so.
Okay. Now we're in the polling places. I don't remember that being part of our bill.
I don't think it was.
That is
And firearms have become
correct.
weapons, dangerous weapons.
That is,
Well, that is my question, is what is a dangerous or deadly weapon? How is that defined in statute? Exactly.
it's very broad.
So
It's in the, sorry, I didn't mean to interrupt you.
is a jackknife a dangerous weapon?
It could be, yes. I will read you the language. It's in the firearms at, possession at school statute is where I believe it is defined, which also prohibits both, firearms and dangerous or deadly weapons. I think that's where this, language originated from. So let me just read you that rather than try and do it from memory. Let's see. All right, yeah, so it's in the possession of firearms at school statute, the prohibition on possession there, but it also prohibits dangerous or deadly weapons. And actually, it's been both the court statute and the possession of firearms and dangerous or deadly weapons at courts as well as schools. Means any firearm or other weapon, device, instrument, material, or substance, whether animate or inanimate, that in the manner it is used or is intended to be used, is known to be capable of producing death or serious bodily injury.
Animate, could that be a dog? I mean, why would,
If you use it to kill someone,
Well, I mean,
why would animate be at issue?
Never thought of that. Interesting question.
I also thought that was rather
Maybe.
strange.
I think it's gotta be a dog, like.
curses.
The problem is.
It's so broad.
Is people's right to vote. That's not, excuse me, reword. The problem with this amendment to me is many people come directly from work to vote. And their intent is to vote. And they're carrying the jackknife. They have a box cutter because it's part of their work. And they walk in with that and then they're told they can't vote. They have to go put it back in the car and they say to hell with it.
I think dangerous or deadly weapon, especially as defined, is too broad. I could very much get on a gun prohibition.
I think if it was a firearm, I could maybe live with it. But
I agree. This reminds me of what Alice Nitka was always talking about. People get out of their truck, they walk in, they forget they have a pocket knife or even larger on their belt. And suddenly they're running afoul. I think the question these days, the threat these days is, are there people who are going to go with firearms to intimidate other people at the polling places? And they're not going to stand there with a jackknife.
Or a box cutter, or a dog. I take my dog to the polling place.
Your dog is very animate.
She is very animate.
I've been through TSA and watched people have jackknives taken from them. They didn't even remember they had, and I actually had, I forgot I had a cash little thing and it had a little knife on the end of it. And it took it.
Well, TSA takes it to a whole other level.
Well, I
got in
realize
trouble for
that.
yogurt.
Well, I realize that, but
It's a liquid.
the good news is after you turn 70, you don't have to take your shoes off.
Nice.
70-year-olds don't carry dynamite in their shoes.
Apparently.
It's been proven, I guess. Anyhow,
Well, most other countries, you also don't have to take your shoes off.
Are there anything else that they did to this bill?
Well, you just essentially reviewed, so this was a prohibition on firearms in polling places, somewhat similar in many ways to the prohibition in hospitals that you passed a couple of years ago.
Yeah.
Notice is required. Sounds like you're saying you definitely want to strike dangerous or deadly weapon language. There are exceptions for law enforcement, for other government workers who use firearms or weapons as part of their
Where's
official
the
duties.
penalty? Is there one, Eric?
Yes, that's on line 9, page 10. Same as the hospital, 1 year misdemeanor, $1,000.
I don't think I think we went down on the hospitals.
Oh, you're right. I think this, you're right. Hospitals went to $250.
Yeah.
Yeah, so this one.
Which I didn't agree with, but accepted it grudgingly, so
I'm
I like
happy to
this
leave
better.
this as it is, especially because we're removing I also at some point would like to go to the underlying dangerous and deadly weapon definition. It seems real broad.
I don't understand the animate or inanimate. I mean, only way I can, and what is an animate weapon? Like AI? I mean.
Like a drone.
Yeah, like, a dog is the only thing I can think of.
Well, if it's animate, it's a physical thing. Inanimate would be AI or
Well, no.
bots.
Well, no, animate means living.
Can we take this up next week?
I mean, inanimate means not living, like this.
We could take it up after May 10th.
Assuming we're all here, can we take it up next
All
week?
right,
Yes.
sounds good.
Thank you. That was an announcement for reelection. Anyway.
Yeah.
So, that next.
Yes,
thing they
so,
added, it had nothing to do with ghost guns.
the section,
I mean, I
5,
would have asked if this was germane to the bill.
Wait a minute. So on the bottom of page 10, subsection 3, it looks like having a firearm stored in a motor vehicle would be illegal, so now.
no, that's an exception.
Oh, okay, I was like, wait a minute, where am I supposed to put it?
No, so you can use it in
Okay,
your car.
okay.
Okay, so polling places, weapons prohibited.
That's the same, it's really just, it's identical to what you just looked at in section 4. The reason for that appearing in 2 places, because the criminal piece is what you just looked at. This is not a criminal piece. It's appearing in the Title 17 elections law at the request of the municipal town clerks and the elections workers, who said they aren't familiar with Title 13. It would be helpful for them to have the statute as well in the
As long as
election
it's
laws.
consistent with whatever we do in the other stuff.
Yes,
Mhm.
that's right.
Senators should.
Eric, general question about polling places and government buildings. We had a conversation a little while ago regarding municipal libraries and prohibition on firearms. Can you just touch briefly on why we can create this prohibition for a polling place?
Yes, interestingly, polling places is one of the 2 or 3 specific sensitive places that are named in Bruin and in the underlying decision in the Washington DC case the Heller case from years ago. They specifically call out polling places.
As a place where
Yes.
prohibition can be?
Yes,
Okay.
along with legislative assemblies, interesting.
I just want to make sure that's
Yes.
on the record.
Yeah.
Thank you.
Yes, and government buildings, which is relevant to the last section, which I'm about to get to.
Section 6 is a report.
Yep, a report from the Crime Research Group, basically to come up with statistics about the ghost gun provision. That's what it is. They're looking for data on how many offenses have been prosecuted under the ghost gun criminal provisions and civil provisions, actually, that were created in the House bill.
Hopefully, no. Hopefully, behavior changes.
A short report then.
I never mind report, I don't care.
Well, speaking of reports, another one in section 7.
Well, that one is a little bit misleading.
So this one is based on, Senator Hashim, the question you were just asking about sensitive places.
Mhm.
Another one of the 2 or 3 sensitive places that are named in the Bruin decision, specifically as places where firearms can be regulated and have historically been regulated, remember, which is necessary for the constitutional Second Amendment test, is government buildings. Now, it's a little bit unclear as to whether that means all government buildings, or does it mean, there's been some different case law on that, because some government building could be like the salt shed or something like that.
Mm-hmm.
So that part is a bit unclear, but the general core principle that government buildings is a place where firearms can be regulated, is established, so this asks, the League of Cities and Towns and the Association of Municipal Parks and Charters to look at municipal buildings.
There's an interesting history on this particular section. I think it's clear Representative Harrison had an amendment to the bill that would have prohibited firearms in municipal buildings. The House Judiciary Committee substituted that amendment for this amendment.
Correct, exactly.
Because they weren't ready to say whether or not it should happen. The question is, do we want to study this? I guess. We're not bound by this, but I don't know what it hurts.
Is this a recommendation?
to look at it, yeah.
I don't think it hurts to look at it. Are they,
But I suspect it's probably, unless you can clearly define the municipal building, it would violate the Bruin decision if you went beyond. For example, with the recreation park, Bennington has what's known as Willow Park, it's a recreation area owned by the town. Could you ban firearms there versus in the town office building?
are firearms banned in state government buildings?
Yes, I believe that's a matter of BGS policy.
Not here,
I mean, there's signs right outside that say you can't bring firearms
but
in
there's
state
no
house.
law about it.
No, there's no law about it, it's a policy, not a
It's a
law.
policy of
Right.
the building, but there's no violation of law if you bring a firearm into this building. If you bring it into the court, there's a violation of law.
So if there is a consideration to look at,
I hope people didn't hear that.
if there is a consideration to look at prohibiting firearms in municipal buildings, I'd like to add state government buildings to that report. Like, I feel like it would be very strange
Yep.
to have a law saying municipal government buildings, you can't carry a firearm, but the state government buildings, that's fine.
Mhm.
And any private entity, like a grocery store, could say they have a policy that you're not allowed to, because
Right.
that's private and they can make their own rules.
Yeah, I don't have a problem with this report. I just think if we're gonna look at municipal buildings, we should also do the research on state.
That's fine.
I don't know.
Legislative buildings?
Yes.
So do you want to prepare, concur with further proposal amendment, or do you want to ask for a conference committee?
I think further proposal.
Yeah,
Changes aren't that big,
They might
You got
feel
all the
differently,
changes
but-
there?
but I mean, they're
Yeah.
finite.
Yeah.
You know.
I think so, yep.
so
Okay.
They're
we're
not-
going back to our penalties,
Right.
right?
Yep.
Okay, I just want to make sure, I missed the decision point on that. Everything else I think I'm up to date on.
All right, so we'll concur with further proposal amendment. Senator Baruch will report that on the floor once it's prepared.
Happy to do.
I don't, as the bill passed the House yet?
It passed yesterday,
Okay, so it won't be on our agenda till next Tuesday.
right.
All right, committee, good work. Senator Pertwee.
I have a question for you.